So I'm Charina Garcia, and I'm a strategy and immigration partner here with WR Immigration. And just a little bit of information about what we're going to be doing today. We're going to be presenting our first webinar series, Chatting with Charlie. We can move to the next slide. So just a legal disclaimer, this does not constitute legal advice. Of course, it's just for informational purposes only. If you want any advice, opinions, please contact our office and schedule a consultation with us or even with Charlie. We can go to the next slide. And then just a little bit about our firm. We are one of the top rated immigration law firms. We are based headquarters in Santa Monica, but we have offices all over the US and then also in Shanghai. Again, I'm Charina Garcia, the strategy and innovation partner here, and I'm proud to be part of this webinar with our new team member, Charlie Oppenheim. He just joined us and he leads our government relations group. He was the chief of the State Department's Visa Control Unit for 23 years, where he numerically controlled the immigrant visas. As I said, WR is going to be hosting complimentary webinar series called Chatting with Charlie. So Charlie, welcome, and can you give us some insight on what these monthly webinars will cover?
Sure. I'd like to start off by saying it's my honor to be now with the WR immigration firm, and I'm looking forward to these series once again and dealing with the public. The webinar series, we're going to normally try to hold them on either the 15th or 16th of every month, at which time normally the Visa Bulletin should have been published, and then we'll be able to provide some guidance and insight into what the Visa Bulletin that has just been published is talking about. And we feel that these webinars will focus mainly on projections and predictions and certain guidance of strategic visa planning, which can be geared toward the human resources managers and as well as interested listeners. And we think this is very important because understanding the numerical control process can really be clear as mud unless you have to deal with it on a regular basis. And even then, some of the people that deal with it on a regular basis have a hard time with some of the concepts and figuring out exactly why certain things are being done. And so one of the reasons I wanted to join the immigration firm is that I feel that my 23 years as chief of the Immigrant Visa Control and Reporting Division kind of give me a unique opportunity and insight into what is going on when State Department is publishing the new visa bulletins and what the thought process may be behind the visa availability issue and why dates may or may not be moving. And I can also answer questions and provide examples so that interested HR professionals and the listeners will know what to expect as they move forward. And during our webinars, we'll try to cover a very broad array of topics, which including the understanding of why categories may retrogress, what causes visa backlogs, maybe some predictions and trends which will help facilitate planning. And again, I will be able to try to answer questions that are important to HR professionals and the listeners based on the new Visa Bulletin. And we will also be examined in greater detail in later webinars, developments that we're seeing in general on the immigration front for employment visas in primarily. And back to you, Charina.
Thanks, Charlie. So for today's program, we encourage you to ask questions. We'll try and get to some of them. Please don't use the chat function, use the Q&A function, and I'll be monitoring the Q&A. And we will be sharing a recording of this, and you can feel free to share it with your networks. So with that, we're going to take it away, and I'm just going to provide a little roadmap. So first of all, we're going to go through the history and mechanics of the immigrant visa system, the employment-based preference categories, chargeability, backlogs and retrogression, prediction and trends. Now, this webinar is not geared towards family-based. It's really geared towards employment-based. So that's what we're going to be talking about. And I know Charlie said it can be as clear as mud. I'm going to try and make it as easy to understand so that I can understand and the rest of the HR professionals can also understand. And I know, Charlie, we're going to have some differences in opinions and terminology, but that's okay because, you know, you're the technical side and I'm the more day-to-day side in terms of what we hear from our clients, the employees, the managers. And, you know, the reality is it's very frustrating to wait. And what we want to do with this webinar is kind of give you an idea of why is the wait so long and why it tries our patience in terms of our employees getting their green card. So with that, Charlie, give me a history. How did the numerical allocations evolve? What are the factors that control the Visa Bulletin? And when does a Visa Bulletin get released?
Well, the last major immigration reform took effect in fiscal 1992 and was the result of the Immigration Act of 1990. And that changed both the family sponsored preferences and expanded the employment-based categories and greatly increased the annual limit for employment-based applicants. The pre-1992 limits were 54,000 a year for employment applicants, and the new Immigration Act increased that to a minimum of 140,000, which at the time Congress thought would be more than sufficient for employment immigration. And as we now see, that total is unfortunately woefully low at this point in terms of the demand for employment applicants. The annual limit, the Congress set an annual limit which has been in effect for the family categories of 226,000. That is a minimum, and that minimum limit has been in effect since about 1998. They also said that the employment limit would be a minimum of 140,000 visas, and they would add to that figure any unused numbers from the previous year's family limits. So they didn't want certain numbers to go unused, and that has been very beneficial in many years. For example, the last several years where family number use has been much lower than the allowable annual limit there. So those unused family numbers have gotten added on to the next year's employment limit. There are per country limits, which Congress deemed necessary to try to prevent a handful of countries from monopolizing the use of all of the numbers in certain categories. And they said that it would be a 7% limit. And on employment categories, they made a new provision which said, if the rest of the world is not going to use all of their numbers, then any of those unused numbers can be made available to countries which have already reached their 7% per country limit. And that's provided a great benefit to Chinese and Indian applicants in recent years.
So just to pause there, so how much discretion does the agency have in using these extra numbers? Who do they actually go to?
What would happen is on the otherwise unused numbers, and I'll just try to give a very easy example. Say if the overall limit was 100,000 numbers, say for the second preference category, and so of those 100,000 that India and China were entitled under their per country limit to say 5,000 each, we would know that India and China are going to use a total of 10,000 numbers. So we'd subtract that from the 100,000 total available. Then when I was chief, I would try to estimate, okay, how many numbers will all the other countries in the world need? And I might say that, okay, the rest of the world will need 70,000 numbers. So we still have 20,000 numbers available under the annual limit. And I would give those numbers, those 20,000 otherwise unused numbers, could be made available to applicants from the countries with the earliest priority dates. And typically that would be, those 20,000 numbers would typically go to Indian applicants, because the Indian applicants in most of the employment categories, the first, second, and third, Indian applicants typically have the earliest final action date.
So basically, the numbers are going to the countries which have the highest demand based on the date of filing of their, what we'll just call it priority date, which we're going to talk
Correct.
about.
The filing date of the petition.
It's not based on whether you're Chinese or Indian or Japanese or whatever. It's based essentially on your place in line, right? And what country of birth you are from.
Exactly. And that's why it's very important for applicants, when they have the ability to file, that a petition be filed as early as possible, and for applicants when their turn comes up to proceed to final action as quickly as possible when they're asked for information.
Okay, and where's the Visa Bulletin, Charlie? Where's the middle of the month? Where's the Visa Bulletin? Did it come out yet for January?
I looked right before we went on, and it is still not out. And I know this is extremely frustrating. To be perfectly honest, it was extremely frustrating for me for about the last 4 years or so that I was working. There are two reasons why the January Visa Bulletin may not have been posted yet that I can think of. The first is that in 2018, there were additional clearance requirements added to the State Department. Sends out a cable to all of our overseas immigrant visa processing posts. That cable,
what's a cable, Charlie? We don't live in
cable
cable
is like
world
in the
anymore.
old
What's a
days, if
cable?
you would send, if you'd send a Western Union telegram. But the State Department still sends cables to the overseas post, and the cable that would be sent out, it's essentially the same information that is in the Visa Bulletin with potentially some administrative information added on. But the State Department has to clear that through regional bureaus now and the Assistant Secretary for Consular Affairs. So there's more layers of clearance required now than pre-2018. That can cause delays.
Just to simplify it, so if you're getting ready to prepare to publish the January Visa Bulletin, how much prep time ahead of time are the agencies going through? A month, 2 months, 3 weeks, 2 weeks?
For the clearance, it's basically going through the chain of command. So it's going from the, say on a HR perspective, the supervisors to the managers to the CEO. And then
it
once
could take weeks?
No, that normally takes 3 to 7 days to clear through. So
someone's on vacation right now because
somebody, for whatever reason, the CEO, quote CEO, has not cleared it so that can go out to the public, to the overseas post. And until that cable goes out to the overseas post, it cannot be posted online, the Visa Bulletin. The other reason, and more probably, is there's a lot of number use going on, and the State Department and USCIS is concerned on what they are doing with the final action dates. And they may have wanted to delay action on the January decisions on those dates until they could see what was happening during the first, say, week or two of December, to see what the demand was really like. Was it matching what they expected? Was it higher or lower? And based on that, then they would make their decision on what to do with January. But I really would expect within the next several days that the bulletin, regardless of which issue it is, it should be published no later than Monday.
Okay, and when was the latest it was published in your career?
We had a time or two, I think in 2019, when it was delayed till the last day of the month. I think one of the bulletins the November bulletin didn't get published until October 30th because of administrative delays. Again, those are the rare occasions. Normally, I would say that the bulletin should be posted online between the 12th and 15th of the month.
Okay, but we're already at the 15th, so
Right.
maybe the 20th is what you're saying? The 19th?
Yeah, I would say
20th?
Monday.
Okay, that's your prediction, right, Charlie? The 19th or 20th?
Should be a worst case scenario.
Okay, worst case scenario, 19th or 20th. Okay, we can go to the next slide. All right, so Charlie, when I started my career in 1997, you, in my eyes, as a new young associate, were the Wizard of Oz. That was the ongoing joke with our friends, was that you were the person where we didn't understand what was going on, and you would just issue these numbers, and then our clients would be happy and we'd be able to file their green card applications, right? So kind of walk me through, not in a high technical level, but more at a level where I'm going to understand it. How are these visas allocated, these immigrant visas, or we want to call it green card, when there are extra numbers?
Right. In this chart, any of the numbers that are not used in the EB1 category, if they're not used there, they can fall to the EB2. And if they're not used in EB2, they can fall and be used by the EB3 applicants. In the EB4 category, if those numbers, either the EB4 or EB5 numbers are not used, they get added back to the EB1 limit.
Okay.
And then if not used, they can fall down to the third. So it's it's a convoluted system in a way.
Yeah.
I mean, the way the numbers fall down, up and down and sideways, but the goal of allowing numbers to fall up and down is to try to maximize number use because there are so many employment applicants waiting. The goal is to make sure that every last number is used so that the government does not increase the waiting time any more than is necessary.
Okay, so when do the numbers get released? What is the fiscal year? We see all this fiscal year 2021, 2022, 2023. What's the fiscal year?
A fiscal year is October 1st. So the fiscal year 2023 started on October 1st of 2022, and it will go through September 30th of 2023.
Okay, so on October 1, 2022, all the numbers were available, plus the extra from last year that was unused by family base. Is that right?
Correct. So we had the government had a brand new annual limit, which they have already announced will be approximately 197,000 employment numbers for use in any of these 5 categories during the next year, October 1st through September 30th.
Okay, so what happens if for some reason not all the employment-based numbers are used by September 30th of 2022? What happened to all those numbers? Were they all used up or where'd they go?
No. Unfortunately, if all the employment numbers for the past year would have been used. I think that they're very close. The annual limit was approximately 281,000 for fiscal 2022. And I believe that when the information is published, I think that those limits will be met. I think that between 275,000 at least 275,000 numbers out of the 281,000 are likely to have been used.
So you closed out your term at Department of State using up all the numbers, every possible number you could use before you retired. Is that right, Charlie?
No, that I retired during the first quarter of 2022, but I left them strict instructions to make sure the annual limit was all numbers were used. I said if they weren't used, I was coming back to scold them.
Oh, great. All right, let's move to the next slide. So a lot of people ask a lot of questions in terms of what are the annual limits, and we got this chart from the Department of Homeland Security, right? So can you kind of just walk us through a little bit through these numbers and the annual limits?
Sure. In the previous slide, it showed EB 1, 2, 3, 4, and 5, and here those are represented. So the employment first, second, and third preference categories for employment first, they each received 75,014 numbers, and for each category. And the fourth and fifth preference categories each received 18,623. And the overall annual limit for fiscal 2021 for employment was 262,288 numbers. Each of the 5 employment preference categories receives a percentage of that number. So the 75,014 for first, second, and third represent 28.6% of the overall 262,288 limit, and the 18,623 limits for fourth and fifth represents their share being 7.1% of the numbers. And these percentages apply each year. So the employment first, second, and third will each year receive 28.6% plus potential unused numbers of the overall employment annual limit.
Okay, thanks for sharing that. Let's kind of move to the next slide. And this actually is a slide that I thought would be helpful for us as we educate our HR professionals and also understand why many of our employees are asking that they move to different categories, right? And I think if you look at this includes family-based, right? So if you look at the total number of admission, 740,000 in 2021, of those 26.1% were employment-based. So when you think about all the immigration to the US or the green card issuance or immigrant visa issuance, the employment base that is sponsored by employers or self-sponsored by employees through these categories, which we'll go through, is 26%, right? And many of our clients are always asking to be a priority worker, which is what we call EB1, right? And so you're always seeing people ask to be EB1, and you see that 8.3% of those numbers went to EB1 workers. But if you look at the EB3 skilled worker professionals, this is where many of the employees will sit when they graduate from college, right? They have a bachelor's degree. You're at a 7.3%. And we always hear as attorneys and our HR professionals, I want to be EB2. I want to be EB2, right? I don't want to be EB3, right? And so you see the difference, 8.1% versus 7.3%, that makes a difference, right? And that's why you have a lot of employees that will say to you, can you please put me in EB2, right? EB1, even though you look at it and you say 8.3 versus 8.1, that's not a large percentage number. But I think the key difference is the speed, right, Charlie? The speed in getting the green card.
Correct. So if you had an China or India EB1 applicant in recent years, that category is current, meaning once the petition is approved and the applicant has all the required information, they could potentially receive their green card. Whereas in the third preference, an Indian or China applicant is facing an extended wait of many years.
Yeah, and we'll go through that. So we can go to the next slide. So I just wanted to show, because we have a lot of questions, like why do our Indian employees and Chinese employees have to wait so long, right? And this chart is also from the Department of Homeland Security, and just the admission of green card holders. It's called lawful permanent residents, but in our world, we just call it green card holders, right? And if you look at Mexico, high, but that's also due to family-based, right? So there's a high percentage there. If you look at India and China, it's also family-based, but it is also a lot employment-based. And you see the top 3 countries is Mexico, India, China. So hopefully for these HR professionals, they kind of get an understanding of why there is a increased demand, right? And that's why the waiting time is so long. So if you look at the demand, Mexico 1, India 2, China 3. And we can go to the next slide. All right. So now we're going to talk about the mechanics of the Visa Bulletin. So when we're talking about the Visa Bulletin, there's 3 dates that are really important. And the date that everybody always wants to know is, what is your priority date? And the priority date is established by, if you're filing your green card or sponsored through PERM, it's the date the PERM was filed with the Department of Labor. Okay. That locks in your priority date. So when you have employees saying, can you rush my PERM? Can you file my PERM? It's because they want to lock in that date, because once they lock in that date, that's their place in line, right? And that date follows them when they move employers. And right now it's taking a long time to file a PERM. It's taking 10 months for the prevailing wage to come through. Then we have to do recruitment. So people are waiting a long time just to get their priority date assigned for their case to be filed. The other way to establish a priority date is if you are under the EB1, I-140, right? So if you meet the category, which we'll go through, if you are self-sponsored under EB2, National Interest Waiver, or you're a Schedule A. Now that's the important date. That's date 1. Date 2, dates for filing, and we're going to run through this too. This is the date that the Immigration Service will allow you to actually submit your application. It's like pre-simmering, right? And National Visa Center does a lot of pre-simmering too. So usually the National Visa Center, if you're processing abroad, they start sending you letters and telling you to get prepared, for your date to be called. So the USCIS started doing the same thing. Let's get all these cases in the queue so that once Charlie calls the date, right, then we can issue the green card or the immigrant visa, right? And so the final action date is the actual date that the Department of State can issue the immigrant visa or the USCIS can approve the case, right? So those are the 3 dates that are really critical, is the priority date, which is what everyone wants to rush to do to get a date, and then dates for filing, and then final action date. So we can move to the next slide. Okay, Charlie, here's the Visa Bulletin. This is dates for filing, right? So walk me through this. If I'm from India, I'm born in India, and I'm being sponsored under the second preference category, date is May 1, 2012. What does that mean for me?
What that means, the dates for filing are where the State Department believes the final action dates will be in approximately 8 to 12 months in the future. And so, as you said, they want people to be able to file based on this May 1st, 2012 date. If they have a priority date earlier, they can file, and their application which they've filed, the Immigration Service or State Department can begin working on that so that when in 8 to 12 months, they will have finalized all their processing on it, and the applicant can either, their status can be adjusted here by USCIS in the States, or they could be issued a visa overseas.
What happens if it doesn't take 8 to 12 months? It takes longer.
That is, if it takes beyond that, then they would just have to wait their time. Again, this May 1st, 2012 date is where, in consultation with the Immigration Service, the State Department believes the India second preference date will be by September of 2023. So their intention is no later than September of 2023 that an applicant with a priority date earlier than May 1st, 2012 from India will have been issued a visa overseas or adjusted status in the U.S. If, unfortunately, sometimes their projections will be wrong if there's unexpected demand.
Yes. And, the weird thing that happened where everybody was up in arms was what happened to all chargeability areas? Why is there a date there? Why is it no longer C, right? I always look at it and it was current. Now I have to tell my clients, oh, sorry, wait, you charge all chargeability, all other countries is now no longer current.
Yeah, that fact had me a little puzzled myself, and I did it for 23 years. So do not feel bad. It seems a little bit strange that given the fact that the rest of world second preference date has been current for many, many years, meaning there's visas available for everybody who has a petition filed, why is there suddenly too many people, especially given the fact that the annual limits for including 2023 for the 2021, 22, and 23 are the three all-time high employment limits. So given that fact, and plus the fact that the category had always been current before or for an extended period of time, where did all this demand suddenly come from?
Let me speculate. Let me just speculate. I don't know anything. I don't know anything about numbers. I don't know anything about percentages. All I know is it's taking a long time for our clients' adjustment of status applications to be processed. And if you have 8 million and then it's still open and now there's another 500,000 coming in, I think the backlog just keeps growing bigger and bigger. That's just my speculation. It's, nothing proven. But let's move to the next. So this is the actual December Visa Bulletin, and this is the final action date. So if my date, Charlie, if I'm from China and my date is August 1, 2018, right? Is my immigrant visa being issued or my green card approved yet?
You said second preference?
Third preference, August 1,
third preference. Your priority date has to be earlier than August 1st of 2018 if you're a China employment third preference applicant. So that August 1st, 2018 date represents the first Chinese third preference applicant whose case could not be finalized and issued a green card during the month of December 2022.
Okay, so walk me through this. I'm looking, so the chart I showed before, I said my employees always want to be EB2, right? So EB2 India, let's just look at that. EB2 India, EB3 India, right? So why is the date faster under EB3 India versus EB2 India?
EB3, this is where I mentioned that there are 7% per country limits imposed. Based on the amount of demand that is known to the State Department, there are under that 7% limit, they have enough numbers to process India third preference applicants with a priority date earlier than June 15th of 2012. But given that same 7% for an Indian second preference applicant, they do not have enough numbers to process cases for any applicants with a date of October 8th or 2011 or beyond. It's one of these strange occurrences, but one of the things is during 2021 and 2022, the State Department and Immigration were able to work off more of the India third preference backlog than they were the India second preference backlog. So that is allowing the third preference date now for India to be beyond that of the second.
So let me tell you what happened in my world, right? I had all these clients sitting patiently waiting in EB2, right? And then we see that it jumps, right? And EB3 is faster. So we called it lanes. Like if you're driving in a lane, you're staying in the EB2 lane, right? And then all of a sudden you see the EB3 lane. It's going faster. So let me move to the EB3 lane, right? And I'm in the EB3 lane, so what we call downgrade, I'm in the EB3 lane, then all of a sudden EB2 becomes faster again, and now I want to move to the EB2 lane, right? So all of this maneuvering is going on in lane movement, right? How does that impact when I'm actually given the number, the actual number? If I'm moving from lane to lane, how are you counting me 3 times, 2 times? What is that? What's happening there?
No, you're only getting counted in the lane you are when you're reported to the State Department. So, but if you're changing lanes, say, for example, if you are an India second preference applicant today, and you see that India third is more advantageous, you decide to downgrade to India third. Well, at the moment, State Department has you counted that you will eventually need a number in the India second preference. Until your case has been actually fully downgraded to third, you will remain being counted as a potential second preference applicant. Then once your downgrade is approved, they will remove your second preference reference and put you into the third preference consideration. And that's why, when there's upgrades or downgrades, typically it's upgrades for example, the China's third to second is a better choice. The India's second to third is a better choice. So you're going to have applicants flip-flopping, and at some point, all that flip-flopping is going to have a potentially devastating impact on the new lane, causing that new lane's date to either hold and not move forward for a period of time, or potentially retrogress. But the lane changing causes chaos not only for the HR managers and the attorneys who are practicing and having to do all this, but it also is somewhat of an administrative nightmare for the government, because we can only count you in one lane at a time, even though you might be trying for 2 different ones.
Thanks, Charlie. Okay, let's move to the next slide. We're talking about categories, right? So I'm just going to define the categories. So EB1 is individuals of extraordinary ability, outstanding professors, researchers, multinational managers, and executives. EB2 are advanced degree professionals. So these are with a master's degree or bachelor's in 5, national interest waiver, and those of exceptional ability. And then we have our EB3 professionals, the skilled and unskilled workers, right? And we just usually think about it in my world. If you're EB3, you have less than a bachelor's and 5 years of work experience. If you're EB2, you have a master's, or you have at least a bachelor's and 5 years of work experience. And then of course, EB1 has its own criteria. So we can go to the next slide. So we already talked about the annual limitations, right? You talked about that, and the different preference categories. What happens to the dependents, Charlie? Like, are they like one number and all my 6 children are counted under my one number, or what happens with my 6 kids?
Yes, the principal applicant and all dependents are charged against the annual limit. So early on, you showed that the employment first, second, and third preference limits were approximately 75,000. If you've got a family of 5, then that's 5 numbers reduced from that 75,000 figure, and you keep reducing numbers until you get to 0. Ideally, you get to 0, meaning you've been able to use all of the numbers during that fiscal year.
Okay, but you wouldn't separate families, right?
The intention is not to separate family. Unfortunately, sometimes the entire family is not listed on the same petition. For example, the principal files a petition, and at the time they have a spouse. So the petition lists 2 people. Then the subsequent to that, in their long wait, they have a child or two or three. If those one, two, three children are not tagged on to the original petition, they can become separate for the USCIS processing. And that is what resulted in some applicants. The principal may have received a visa in 2023 before there was a retrogression, and in 2023, their dependents may not be eligible based on the applicable final action date at this time.
Yeah, well, we'll talk about retrogression and backlogs in a little bit. We already talked about how people move up and down from EB2 down to EB3, EB3 back to EB2. So we'll move on to chargeability. So Charlie, in a nutshell, what's chargeability?
As I mentioned, in the principal applicant, people need to be charged against the annual limit in the category they're processing. They also need to be charged against the per country limit. So normally an applicant's chargeability is deemed to be their place of birth. If, for example, a child was born, their parents were in a country that was not their original place of birth, and the child could be cross-charged. So say that the parents were in India at the time of the child's birth, but they were from Great Britain. Well, the child would have been born in India, so in theory, they should be charged against the annual limit for India. But because they were born in a country of which neither parent was a resident, they could be cross-charged to the parents. Another way to look at it is if, say, the principal applicant is an Indian second preference applicant, they marry somebody that is from another country in the world which is not oversubscribed, the principal could be considered the principal applicant for preference category and preference category, and the spouse who, say, was born in, again, Great Britain, they could be deemed as the chargeability. So the husband would be cross-charged to the spouse's Great Britain foreign state, allowing them to immigrate even though they were born in India, and they would use a number under the Great Britain second preference category.
Okay, so that's cross-chargeability. Unfortunately, it doesn't happen very often in my world where the spouses are, they're born in India and also marry people born in India.
Exactly.
So let's kind of just run through some of the most oversubscribed countries, which I kind of gave a chart to if we go to the next slide. So of course, China, India, and then for many of the family base, it's Mexico and Philippines. Now let's move on to the backlog and retrogression, right? Now I understand it's about supply and demand, right? And so we're going to kind of walk through the backlogs. How do they occur? What's retrogression? What's the impact of retrogression on the waiting period? And then what can be done in advance of retrogression? I found this slide, the next slide. And this is what the USCIS says why there's retrogression, right? These are their factors they look at. And Charlie, maybe it's the same for you. The potential that a certain percentage of applications will not be approved. That's what they look at, one of the factors. Accounting for non-citizens who have multiple pending adjustment of status applications in different categories, which we have, right? Estimating and considering the number of family members who may decide to immigrate with the principal applicant. Considering where applications are in the adjudication process and how likely they are to result in visa use in the immediate future. And adjustment of status applicants with multiple pending or approved immigrant visa petitions in different employment-based categories who may decide to transfer between categories based on which category seems most advantageous to them. That's what we call changing lanes. So we go to the next slide, Charlie. Why don't you kind of walk us through retrogression and backlogs using this example?
Right. Say that state is right now just trying to determine what the January or worldwide second preference date may or may not be. They decide they have an allocation target, and there, as I mentioned earlier, there's an annual limit on the amount of employment-based numbers that can be used. And if you think of that as your household budget, you have a fixed amount of money based on your salary, which you will have available to use for the next year. So you establish a household budget, how much money you think you're going to use on a monthly basis. Then you, after the end of that month, before the next one is coming, you'll review how your estimates for your budget needs were going to be versus your actual needs. So the State Department does the same thing. They decide we want to use 2,000 numbers for the month of January. That we only have 1,000 applicants who have been reported that they're documentarily complete. They're ready for their final action, either overseas or adjustment of status. So their target is 2,000 numbers. They only have 1,000 applicants, so they do not need a final action date. They can leave the category current. But then when they're determining the February dates, they again want to use 2,000 numbers, but suddenly there has been an influx of applicants. They now know that they have 8,000 applicants competing for the 2,000 that state wants to use for February. So they would either have to establish a priority date of the 2001st applicant so that they do not go over that amount, or if there was already a date in place, they would have to retrogress the previous date, again, retrogress it to a point so they would only give out 2001 numbers. And again, think of it as your household budget or your budget for your company, and you have to reevaluate on a monthly basis so that at the end of the year, you've reached your maximum allowable use of money.
Got it. So basically, it's based on estimates, and then sometimes those estimates are not correct, or processing times or things like that, and that's what can cause backlogs and retrogression. Exactly,
because a lot of the state is having to rely on estimates from the Immigration Service, how fast cases are being adjusted, green cards are being issued. If that information proves to be incorrect, it can cause things such as retrogressions. Differences in annual limits can also have an impact on what the dates may be.
So we have 10 minutes left, so I want to we're going to skip 2 slides and go to prediction and trends, because all the questions are asking about, Charlie, with your crystal ball, tell us your predictions. What are your predictions? What's going to happen? What do you think we're going to see in the Visa Bulletin that comes out by the 19th or the 20th? And how long do you think the retrogression will last? So kind of give us some of your prediction and trends.
All right. Based on the information that was published in the December bulletin, I believe that the State Department is going to impose a China employment first preference and India employment first preference final action date for the month of January. So let's go back to
can we show the December Visa Bulletin final action date so people have a point of reference? While Charlie's talking about what his predictions will be.
So when this comes up, you see that the first preference across the board is current for the month of December.
Yes.
I believe when this appears for the month of January, I believe that China and India first will no longer say C. They will have a date, and I believe that date, I think this could be a worst case scenario, but I think that there's potential that the date listed for India and China first could be as early as July 1st of 2021. I think that would be a worst case scenario, but I think that they may go back that far when they establish a date, because as HR managers and listeners on the line will know, that for the month of October, they retrogressed the India second preference final action date. They held it for November, and then for the month of December, they once again retrogressed the India second preference date. That's 2 retrogressions within a 3-month period. I would have avoided that, and this is, at all costs. My goal, whenever I had to retrogress a date, was to do it one time, kind of describing it as ripping the Band-Aid off, have everybody feel the pain once, and then I would establish it at a point where I could either hold the date for a period of time if necessary until I saw what was going on in terms of number use, and then I could slowly start advancing the date. But I never wanted to have the situation that has happened here, where again, 2 retrogressions within a 3-month period. That is why I believe they will set a very early India and China first preference date, then maybe hold it to see where number use is going, if that has kind of stemmed the flow. And then ideally, they will be able to slowly start moving that date forward in the future.
So when you say hold it, you're thinking they may hold it for a couple months, few months?
Yeah, I would say that there is a good chance that they would hold it for a month or 2. Again, they want to see, okay, we retrogressed this. Did the retrogression have the desired impact on number use? Or are we still getting more demand for numbers even with this retrogressed date than we can accommodate? If so, they may hold that date for a period of months, because even though, say, they may be still having too much demand for the month of January, if they hold the date for a couple months, then it would, over the period of several months, it would kind of even out to the amount that they wanted used. Again, I may be over my target for the first 3 months, but over a 6-month period of holding the date, I even everything out. But again, I do believe that they will, when they establish the date, it will be, early. And again, as a worst case scenario, I think as early as July 1st of 2021, hopefully maybe
across
only
the board, or just India and China for each?
Just only India and China first preference. And the reason for that is the State Department they know that there's the 75,000 limit for worldwide on the first preference. They have to give an opportunity for applicants from every country to potentially use their 7% limit. Historically, only China and India are the countries which ever reach that. So they know that they're going to use that, but they have to allow the rest of the world to stay current. And then at some point, hopefully they will decide that there are going to be otherwise unused numbers and then they can start providing those numbers to India and China. When that will happen, we'll kind of have to see. I think it could be a couple months, and ideally State Department will maybe give some type of estimate on visa availability in the coming months that would give an indication if they think that the India and China employment first date may be able to be starting to advance.
So do you think EB3 India is still going to be faster or ahead of EB2 India?
Oh, I would definitely say so for the foreseeable future. I think that the India third preference date has the potential to move to July 1st of 2012. Which would be a 2-week movement for the month of January. But I believe that they will hold the India, and again, because of the second retrogression which occurred in December, I would expect them to hold that India second preference October 8th, 2011 date until they are very comfortable that they have that they will be able to start moving it forward, that they have numbers to do so.
So from what I'm hearing is it might be wise for those who changed lanes to EB3 to just stay there for a bit.
It probably, and I will tell you, in the past several years, and with employment second preference being current for rest of world, that meant there were otherwise unused numbers which could be made available to India's second preference. The fact that there is now a worldwide second preference date means that the State Department does not believe there are going to be any extra otherwise unused numbers that can be fall to India. That means India and China second preference will be governed strictly by their 7% of the limit.
Yeah. And it's still early in the fiscal year, right? Because the fiscal
year is and that's one
October 1st.
One ideal thing is that, that they imposed the worldwide second preference date as a kind of a placeholder so they could get an idea of what number use is like, and then they can slowly start moving that date ahead. I believe that date will move to the worldwide second preference date will move to December 1st of 2022 for the month of January. And again, I think that by having a date, they're going to make sure that they have number use under control. And because of the amount of demand they have for India and China second preference, they could potentially wait to move those dates until later in the year and still easily be able to use all of the available numbers.
So you think by September 30th, 2023, there'll be more movement, or we're just going to have to wait till October 1 of 2023 to see more movement?
I think that when they established the application filing dates, they should have looked at all this information. They should have determined the potential demand and number use, and based on that, said that we think at the end of September, we will be at those those application filing dates. So based on that, I would believe that the India second preference date will begin to move forward, but it's just when that will occur. And it may move in slow movement. But again, I think that they're going to want to make sure that they have things definitely under control and not have to have a third India second preference retrogression.
Okay. Well, so we only have a minute left. For our next upcoming chatting with Charlie, we can move to the last slide. Yes, I'm going to host it again, February 15. We're going to take a deeper look for global mobility professionals on the immigrant visa backlogs and solutions. We kind of gave you a teaser here, telling you a little bit about the Visa Bulletin. But join us February 15, same time, 11 a.m. Pacific, 1 p.m. Eastern. So save the date. But Charlie also has a couple other webinars coming up. So January 10, there's the EB5. And then January 18, of course, he's going to be unpacking the February Visa Bulletin. Maybe we'll have another one where you unpack the January Visa Bulletin because it's not yet out. So maybe we should have another one next week, but we'll see. We're at time, but I want to thank you, Charlie, for our first webinar. I think it was very useful, and thanks for allowing me to ask some of the simple questions that I didn't really understand, but now you've told me in this hour, I understand it a little bit more, Charlie, and I think I can help explain it to my clients. So thank you very much for this very insightful webinar.
It's been my pleasure.